want to thank everybody for joining today. Genene Dunn and I recorded a similar a webinar a while back, and we want to make that available to everybody because in that we had a much bigger discussion or longer discussion around the basics of estate planning, and specifically for our clients. From that, we got a lot of questions back from our clients and our teams. We want to dive into a few of those topics. And then we also had a number of questions from those who registered for the event today. So if you did, in fact, submit a question, we have that. This is right now a live event. If you're watching the replay, obviously it's not, but right now, for those who are listening, you can submit any questions you have to our chat and we will make time. We have 30 minutes to start. I would like, though, Genene to introduce herself and tell us who you are.
All right. Thank you, Cary. So I'm Genene Dunn, and I'm the managing partner at Huntsberger Dunn. We are a local estate planning and probate firm in Tustin as well as Corona. So we have offices in both locations, and we service really all of the local counties. We do estate planning, and then we also do the other end of things, as I like to often say, which is when somebody passes away. And we do handle probate, we do handle trust administration, and also any trust and probate litigation that comes along with that sometimes.
Thank you, Genene. I've had this conversation with estate planning attorneys for, I can't believe it, my 17th year as a financial planner. And every time I talk to you or I talk to one of our clients, estate planning attorneys, I always feel like I learned something new. That's why we're hosting today, is to follow up on some of the things that we discussed, offline. But one thing I'll share is that for our clients who have gone through this process, who actually have still put an estate plan together, or have had to administer one for a parent, they always share with us they feel still overwhelmed. And so the big thing in financial planning is, do you have your estate planning documents done? And they say yes or no. And if they don't, then we bug them for 5 to 10 years to get it done. And then once they get it done, they feel like they're all done. Then they have to actually go through the process of losing a family member and administering the trust. So I'm just sharing some feedback from our clients as they still feel overwhelmed. I wanted to ask you, why do you think that is?
Yeah, absolutely. So, the actual process of handling things when somebody passes away, even when they had their trust done and it was all very well planned, there is still a process that is required for the asset to be able to transfer to whomever's listed in the trust. So, there's two things that I think make people feel like it's still an overwhelming process, or may consider it still kind of a difficult process. One of them being is that it's just foreign to them. They've never been through the process. So there's a lot of terms that come into play that they've never dealt with before, such as trustee, executor, pay on death, all of these different things that they are just new terms they've never dealt with before. There is still some paperwork involved, even in the most well set up estate and very properly funded trust. There's still going to be a process and some paperwork that is involved. Nothing automatically just goes to the next person in line without doing anything. So sometimes it's a matter of just having to do something with that emotional aspect to your family member or loved one having passed away on top of that. And the other big factor is purely family dynamic. So I would say our most difficult cases and most difficult situation where people are having more of a harder time, as we would describe it, is when the family dynamics are a little bit rough and people are not getting along with each other. So they start nitpicking at every single little thing. We have a lot of those cases going right now where it's actually a very straightforward estate. It should go really smoothly, but they just don't like each other. So they're making it as difficult as they can on each other. So those are the two factors that can make it feel a lot more difficult than it otherwise should.
Yeah. And yeah, happy family, right? It's like the, happy family, happy life. There's something, but yeah, I could imagine in our clients, examples too, there's always seems to be kind of a lead person who takes the responsibility of this, and it may be simple for them. But when other family members are getting involved, it's probably where you see a lot of the conflict or delays.
Sure, absolutely. And, we see that all the time too. Even when we have multiple people named as in charge, almost always there's one person who really does take charge. And, they're the ones who, again, yeah, maybe they have more of the information, they're doing the work, but then there's other people who maybe feel a little bit left in the dark or out of the loop because it's been months without hearing anything. And I always tell them, that doesn't mean nothing's happening. We're just not running every single little detail across everybody and making sure that they're knowing every single detail that's going on. That's the whole point of having a trustee in charge of things, is so that we don't have to have every single person involved with every little detail, making every trip to the bank and things like that. So
Right.
absolutely, that's a part of it as well.
Yeah. So I have something I wanted to share too with everybody, but we talked about this last time in the first video, is the probate cost. And so a lot of our clients are, I think, they have a little sticker shock. And one of the questions we'll get to later is about DIY online services, or hiring someone like yourself. Is they have a little sticker shock where you hear these prices in the industry somewhere between $1,000 and maybe $5,000 to get a estate plan completed. Our advice is always, well, it's going to be a lot less than the probate fees are. And I think this is still very mysterious. But the last time we did this, the first time we got together about this, you shared with me, no, it's very straightforward. Can you share with everybody how it works? And obviously this is California, but how it works in the state of California. While you're doing that, I'll pull up the chart.
Yeah, absolutely. So the way probate works in California is that the fees for going through probate are set by statute. So what the attorney who's advising the administrator through the process on gets to get paid through the probate is set by statute, and there is a schedule for it. So it's 4% of the first 100,000, 3% of the next 100,000, 2% of the next 850,000, 1% of the next couple million, and so on and so forth. The administrator and the attorney for the administrator both get to collect those fees. And then there's also probate costs, court fees, appraisal fees that usually amount to about $2,000 per estate that also go into it. So it is very straightforward. It's set by statute. The hardest part for people to wrap their head around is that it's gross. So a lot of time people think, well, yeah, I have $1 million property, but I only have $300,000 worth of equity in it. Well, I always compare it to, if you were to sell your property, what are you paying the realtor? You're not paying the realtor a percentage based on your net proceeds from the sale. You're paying the realtor's commission based on the sale value. It's the exact same way in probate. The fees are based on the gross value of that property or the assets going through the probate.
So let's say that again, because I think that one does, people do get lost on. They go, okay, they look at this chart and they go, well, I don't have $1 million. I only have, I have $106 in savings and checking. Yeah, I have a house and I've got a check coming in every 2 weeks. But if my house is worth $700,000 in Orange County and I owe $620,000 on it, what fee schedule do I fall in?
Absolutely. And, when people are doing planning in any way, they are usually looking at their net value. However, right, when it comes to probate and probate fees, it's the gross value. It's the value of that asset itself, regardless of what liens are against it. So yes, if you have a property worth $700,000 in any county in California, your probate fees are looking at $34,000 plus some court costs. So no matter what the mortgage is on it, so even if you have a $620,000 mortgage in it, or if there's no mortgage at all, the fees are the same. They're $34,000. Again, similar to when you're selling a property, you're paying those commissions based on the sale price, not the net value, not the net proceeds that you receive from the sale.
Yeah. So really, the cost, if you look at it, is, if you're talking $1,000 to $5,000 to pay for it and have it done, the math is simple. You go, okay, that makes sense. Tell me about the time it would take to go through what we explained already in the beginning. Is like, our clients say it's difficult or maybe it takes a long time, but how long is it going to take to go through the probate process versus, administering a family trust?
Yeah, the probate process is very long. In California, I would say the average is probably still a year. Sometimes it's longer. The fastest I've ever been able to get through, and in the happiest family, is about 8 months. And that is with one child, no other siblings, everything's going to that child. That's also the one handling it. So we don't have any other requirements to any other beneficiaries. So the average, I would say, for our straightforward probate is a year to get through. That means a year to start the process to where we're actually distributing funds to the beneficiaries or the heirs, as opposed to if we have that in a trust. Now, if your assets that need to go into the trust are actually in the trust, there's no probate whatsoever. It doesn't have to go through the court process at all. So if everything's in the trust properly, I would say the average is about 6 months of when we can be fully done with the administration. That means checking all of the boxes, making sure we've done everything that we need to do, and be able to distribute to the beneficiaries everything in its entirety. There's a lot of stuff that happens in between there. There's a lot of different factors that depend on the assets and the family dynamics that can make that go longer. But in, again, the most straightforward cases, it can definitely be all completely done within 6 months.
So real estate's a big part of our clients, net worth and obviously yours. Tell me a little bit about what's going on in your world with Prop 19. Maybe give us, for those who don't know, tell us a little bit about what Prop 19 is and then things that you are working on with your clients to help plan around it.
Yeah, Prop 19 was a really big change to the law in California. Now, I think it was back in 2021. So the significant factor in Prop 19 that's affected our world is that it took away the parent-child exclusion for property tax rates. So it used to be, and a big part of our job, when people would pass away and they had the trust, everything set up properly, a big part of our job was still making sure that kids who wanted to keep their parents' property also kept their parents' property tax rate. Because it was possible, but there's certain paperwork that had to be filed with the assessor within a certain timeline. So we made sure that all got filed appropriately so they could keep that property tax rate. Now, that parent-child exclusion for reassessment is almost wholeheartedly gone. So the assessor's office sees a death of a property owner as a change in ownership and an opportunity for them to reassess the property and essentially have the property tax rate go to fair market value. So it used to be that for the most part, kids could keep their parents' property tax rate when they kept their property. Right. Now with Prop 19, you only get to keep your parents' property tax rate if it was your parents' primary residence, and the child is keeping it as their primary residence. And even with that, there's a limit up to a value of $1 million. So if you have a tax roll value of $2 million, they're going to reassess half the property. And again, only if you fit within that category of their primary residence and you're keeping it as your primary residence.
So primary to primary, $1 million cap.
$1 million cap.
$1 million tax roll cap. Value.
Yes.
The other thing we talked about a little bit on properties was it comes up more and more. Maybe it's families I'm talking to, but it's usually our clients' parents who are getting approached for reverse mortgages. And I never thought about asking an estate planning attorney their perspective on reverse mortgages. We've always been wait to the last, it's a last option for a client, and that's kind of the safe route. Where do you stand on this, and kind of what are you hearing and telling people?
Yeah, it's a common topic of conversation. Definitely, it is also something that I do defer to financial advisors on because they're going to have a better picture of the whole situation. Mm-hmm. However, we are not anti-reverse mortgage. I do think that there can be a time and a situation where it makes sense. The most common I've seen where, maybe they don't have a whole lot of liquid assets and they want to remain living in their home, because that's the key. With the reverse mortgage, you have to remain living in the home, because the second that the borrower leaves the home, I believe that triggers a full call of the reverse mortgage. So if, in the situation where there's somebody who wants to remain living in the property and they're very equity heavy and don't have a lot of cash flow otherwise, I think a reverse mortgage can potentially make sense in those situations. And from our perspective, I don't see them being a huge difference as far as what happens to the property after they've passed. So, the difference with the reverse mortgage is that when the borrower passes away, within the reverse mortgage, that loan becomes immediately due in full. And it's different also because you're not paying monthly against a mortgage that with a standard mortgage, we can have the family just continue to make the mortgage payments and nothing's going to happen. With the reverse mortgage, it becomes immediately due and payable. However, they still have to go through the entire foreclosure process, which in California is not a quick process. Mm-hmm. So most of our clients, when they pass away, I tell them, you probably have about at least 6 months before we're looking at an actual foreclosure sale date. So yeah, you need to make a decision on what you guys are going to do with the property within hopefully the next few months. But once we have that decision, we can usually keep even the reverse mortgage companies at bay, mm-hmm. as long as we're doing something. As long as we're doing something to either pay the loan off, sell the property, anything like that. It's workable.
But I imagine clients, as we talked about at the beginning, they feel overwhelmed. Obviously, the family members passed, they're dealing with that, they're grieving, and then now they're having to get death certificates and do this stuff. And now they hear foreclosure. Yeah. I mean, foreclosure has such a negative connotation to it. You think that would just probably spook most of your clients to begin with.
Absolutely. Yes. Most of our clients, they get really worried even when they get, there's a lot of steps that come from the mortgage company before the word foreclosure even comes up. So it starts with even a notice of default that this money's owed and they need to get paid. And absolutely, everybody does get a little bit nervous and scared when that happens. However, that's required if they want to be able to eventually foreclose on that loan, which will happen on any mortgage, frankly. They have to start with that process. And so while it can be scary to receive those notices, especially in a very difficult time in everyone's life, it's still just kind of the motions that they're required to go for. The difference with the reverse mortgage is that you're getting those quicker than you do in a standard mortgage, because a lot of people have that standard mortgage on auto payment. So it'll continue to take out of the decedent's account until the decedent's account either gets frozen or gets transferred to a different account. So a lot of the times people just don't realize that those mortgage payments are getting continually paid, whereas that's not the case with the reverse mortgage company. So then they start getting different notices than what they're just typically seeing on a standard mortgage.
Yeah, yeah. Pay on death beneficiaries. We talked about this before. I think it's worth talking about again. Bank accounts become kind of the first line of defense for family members to pay, maybe expenses or keep the mortgage alive, or in good terms and not late, and then burial fees and the whole thing. Tell me a little bit about pay on death beneficiaries at banks and what clients may or may not be able to do with accounts like that.
Yeah, absolutely. I mean, when we're doing estate plans for clients, and I tell everyone, what do you own real property is one of the main questions I ask. And if the answer is yes, I tell them all, usually the real property is the primary focus of the living trust, because the main point of doing the living trust is to set up your estate to go to whoever you want and also avoid probate. And with accounts, there's other things we can do. You can put pay on death beneficiaries on accounts, and as long as you have a pay on death beneficiary on an account, it will avoid probate. Whereas it's not as easy to do that with real property. So oftentimes that is a point of discussion. And I do tell everyone too, your trust is only as good as the assets that are in it. So the trust is only going to rule over the assets that are actually in the trust. So retirement accounts, people's, IRAs, annuities, 401ks, those are not going through the living trust. They're owned by the individual. And most of the time they have their own pay on death beneficiaries, and that's how it should be. And therefore those accounts are not going to be in the trust and subject to the terms of the trust. And that's how it should be. With that being said, we recommend to every single client that they have some kind of liquidity within the trust, that there's some kind of funds that are available to the trust to pay for the decedent's final expenses, final tax returns, the attorney that's going to guide them through the process. There's fees that come along with all of that, that there should be some liquidity in the trust. How we get that liquidity into the trust, either the trust can own the account or the trust can be a pay on death beneficiary of an account. But just to be clear, if there are accounts that have pay on death beneficiaries on them, they will pay directly to that beneficiary and will not be subject to probate.
Good.
Yeah.
Want to switch gears here before we go to questions, as we're coming up on our time. In our conversation between these two webinars, you talked about, you just kind of, checking in, you were saying a lot of your clients are asking for custom language. And obviously we won't say who this was, but you said there was a family that you did some work for, and there was some issues. I think the husband and wife were kind of going back and forth on how much they wanted to leave their two children. And then there was a disproportionate amount of grandchildren between the two children. Can you, one, talk about what custom language really means for everybody who maybe has not gone through the estate planning process? And then, if you will, kind of expand on that particular case. I thought that was an interesting, planning subject.
Yeah, absolutely. That's something that we have been having coming up recently is, a standard trust with something unique to that client, where they want this particular part a little bit different than just making sure everything goes equally to the kids. We've been having a lot of that recently. And one of them was, a big point of discussion where this couple had two kids, they're grown adults, and one of their kids has 6 kids of his own, and the other one doesn't have any children. And so even when we were just talking about their distribution, they were contemplating giving the child with 6 kids a larger portion of their estate than the child with no kids. And, it's something that is obviously it's their funds, it's their estate, they can do whatever they want. But the benefit of having an attorney involved in the discussion, especially an attorney who does the administration and sees how these things play out after death, I like to just make sure that they understand what that means practically. And so I tell them, same thing, you're welcome to do whatever you want, but I just want you to think about how that child who doesn't have any kids, who chose not to have any kids, would feel when he learns that his siblings got a larger portion. Because what's not going to go into your trust is why you've done that, typically, why you're giving that kid a larger share. And sometimes, hurt feelings and family dynamics bubble up after the parents have passed away. ultimately, is my advice that they just have a conversation with their children and maybe put something about why this has gone if they've decided to go down that road, because that's what we see of how this practically works out. Another one that comes up a lot is when small families own a small business, and there's maybe one kid who's working in the business and continue to work in the business and will eventually inherit the business. But the other kids had the opportunity to work in the business but chose not to. And so that's a very big point of discussion that we have, because again, every client's a little bit different of, should we just hand this business over to the kid because it's grown because of the fruits of his labor or her labor as well? Or does it need to be that, yes, this child may get the business because they're working in it, but we need to make sure that the other kids are equally compensated, because at the end of the day, we want to make sure that everything is completely equal among the kids.
Right.
And we have a lot of spouses who feel differently about that. There's a lot of times one spouse who thinks we should give it to this kid because they've helped us grow it. But then the other spouse will say, but they were very well compensated while they helped us grow it. So I don't think they should also get a benefit of inheriting, $1 million business or whatever it may be, without the other kids getting some kind of compensation for that. So, it's just those kinds of discussions that people think, oh yeah, let's do this. It's super simple, compared to what that's going to mean, how that is going to feel for all of your kids, how that ends up going into writing and eventually playing out once it comes to play.
Yeah. How's it going to feel for all the kids? We, as a parent of two, feelings are involved in decisions that are made, and you do treat children differently depending on how, right, what their styles are and how they, and it's interesting to hear this thing about the family members, business owners, because obviously a lot of the people listening who need an estate plan and, may be highly compensated or self-employed. And so it comes up quite a bit. And then the idea behind having to give a child more or less, but then not explaining why. And that was one thing I wanted to ask you about, is like, is there a place, an exhibit or an addendum or something you can add to your estate plan with kind of I'm not saying like, I don't want to get all sad here, but like a last letter, a farewell, like, here are the reasons, like, from mom and dad. Is there a way to do that?
Absolutely. Yeah. And it's something that we talk about anytime that somebody's doing something out of the box, or frankly, if they're just not treating the kids equally. I always ask why. Yeah. I always ask why, because I know it's something that's probably going to come up in the future.
And it's something you're going to end up having to deal with. Yes.
So yeah, sometimes we put it in what we call a statement of intent, which is simply just a paragraph in the beginning of the trust, kind of explaining the situation. So a very common one is where maybe we have a commingled family where there's been a divorce, so that there's a set of children who are going to inherit from two different sets of parents. And a lot of what I get is, well, this particular child is going to get a lot of money from their mom when they pass away, but the two kids that we have together are going to have to just split ours, and there's no other family that they're going to be inheriting from. It's a very practical consideration that sometimes we'll throw that in a statement of intent, basically saying that, this child is receiving less percentage because of the expected inheritance that they're expected to receive from a separate source.
All right, rapid fire here. 5 minutes to go. We had 4 questions submitted. Thank you for those who submitted questions. All right, Genene, what should be included in the will or trust? What shouldn't be included? Are online services recommended? Why not?
Sure. So if we're talking about what assets should be included in a will or trust, I usually say the assets that go in a trust are going to be real property, and then any checking, savings, or brokerage accounts. So that excludes retirement accounts. No IRAs, no 401k, no life insurance, annuities, those kinds of things are all accounts that are usually not put in the trust.
Anything with a named beneficiary, as we will tell clients all the time. And make sure, this is a reminder to everybody listening, update your beneficiaries, please.
Yes.
Primary and a contingent.
Yes, absolutely.
What about vehicles?
So vehicles, typically, no, we don't include that in our documents at all. People tend to change their vehicles. A lot of the times they are liabilities more than they are assets. So that is another common question we get as far as what goes into the trust. It's assets. Remember, it's assets. So, we get people who give us their mortgage statement. That's not an asset. That's a liability against your asset, which is your property. So, the vehicles, unless we have a collector's item or a very expensive vehicle that we don't expect to get rid of, then maybe. But vehicles are specifically excluded from probate under the code. And also, they're very easy to deal with post-death, surprisingly.
No, that's good to hear. I assume D&B and I just get scared.
Yes,
All
most
right.
people do.
Question here. Can my wife and I, in quotes, gift our two children, both who are over 30 years old, 18,000 a year without any tax consequences for them? For us, I'm assuming they're talking about the annual gift, and I think it's 17,000.
Yes, I
Yes.
believe I'm also pretty certain in 2023 it's 17,000 per person, but the answer is yes. The answer is yes. What that is basically saying that you can gift up to $17,000 per year per person, completely tax-free without any reporting requirements. Now, the thing to remember is that the estate tax exemption and the gift tax exemption are one and the same. So even if you were to gift more than the 17,000 per year, you have a total lifetime gift exclusion right now of a little over 12 million. So if you were to gift your kids $50,000, you still technically wouldn't pay a tax on it because you have this overall lifetime gift exclusion of 12 plus $million.
Yep.
That just means that once we're past the 17,000, you're supposed to report it.
Yeah,
So
report it, and that sort of that technically takes away or eats away at that
exactly
lifetime gift
chips
amount.
away
So
at that lifetime.
anybody over 25 million is where the gifting becomes a a planning idea to start getting money out of the estate to children, grandchildren every single year and avoid estate plan or estate taxes.
Yeah.
Okay.
Yeah.
Next one, what are the steps needed to transfer ownership of a home through a trust after a parent has passed away?
Yeah. So, that's where Prop 19 comes into the discussion a little bit. Because the thing to remember there is that if we're keeping a property, the taxes may go up to fair market value of that property. If we are trying to keep Prop 19, there's a couple more documents that have to get filed. But generally, if it was owned by the parent as trustee of their trust, we have to do an affidavit of death to show that that trustee has passed away, that parent has passed away, and that gets the new trustee on title. And then to transfer the actual asset itself out of the trust to the beneficiary, then we need to do a deed transferring from trustee to the owner beneficiary. And that's where the reassessment will come, unless you file the other document if you qualify for the parent-child exclusion.
Last one, how can I legacy plan for my newborn? What critical changes do I need to make? So it sounds like a new parent. They're trying to ask, what should I be doing and planning for to leave a legacy?
Sure. So we have lots of clients with young children, and the main thing to think about is guardians. That's what goes into your will. Guardians is going to be who would be in charge of raising the kids if you were not around. It actually doesn't have anything to do with money. So as far as who would handle your assets for the benefit of your kids, that's all typically within the trust. And within the trust, when we have young kids, we do talk about keeping the assets. Essentially, you're going to stay in trust for the benefit of your kids until they reach certain ages, and then it's split and will still be for the benefit of the kids until whatever age you say is appropriate for them to be able to take over their money. And that's usually tiered. Usually it's, they get part at 25, part at 30, part at 35, or they get it all at 25. Every client's a little different on that. But yeah, there's usually some kind of structured distribution pattern within the trust when we have minor children.
Genene, I appreciate your time. It's 12:30. I want to be respectful for those listening. We promised 30 minutes. Genene, you've been a huge asset and partner of ours for many years now, and we thank you for that. We've had you at events before, and you've spoke. You've never asked for anything in exchange. I appreciate your time. Would you give us a quick plug so people know how to get a hold of you?
Sure. Yeah, absolutely. So, like I mentioned, we are a small firm in Tustin, and we're also in Corona, and we can be reached at 714-663-8000, or huntsbergerlaw.com is our website. And yeah, we've really enjoyed working with Warren Street. All of your advisors are tremendously amazing. The way that you guys have cared for your clients and clients that we've sent over has been such a blessing to our clients as well. But we are always happy to work with you guys and do anything we can to provide as much education as possible.
Well, I appreciate that. I said a shameless plug for you, not us, but we appreciate the feedback. So, well, thank you everybody for joining. Again, any questions, please reach out to us, and we hope you enjoyed this time. And again, Genene, thank you so much.
Thank you guys.